Hello again, I'm attorney Robert Flesses for Robbins & Lloyd Career Training Institute. This is part one of course number 7, which focuses on advertising by licensees. Specifically, I'll discuss Wisconsin Statute 452.136 and Article 12 of the National Association of Realtors Code of Ethics, and how those provisions guide you on advertising to the public. Let's get started. Wisconsin Statute 452.136 has 4 sections. Those are false advertising, disclosure of your name, advertising without an agency agreement, and the advertised price of a property. Let's start with false advertising. The statute states as follows: a licensee may not advertise in a manner that's false, deceptive, or misleading. That's pretty straightforward. The statute also has a provision for disclosure of your name. 452.136 sub 2 states, unless you're advertising rental property that you own, you have to disclose the firm's name with whom you work for. And the firm's name must appear exactly as printed on the license of the licensed individual broker or licensed broker business entity, or disclose a trade name previously filed by the firm with the department. You have to clearly indicate that the firm is a business enterprise and not a private party. Now, advertising includes anything that you use to promote yourself, whether it be a business card, your individual website, any type of promotional material like refrigerator magnets, koozies, and a magnetic sign on the door of your vehicle. Anything. The next provision of that statute states that if you're associated with a firm, you must advertise under the supervision of and in the name of the firm. The name of the firm that you use in advertising must be clear and conspicuous unless you're engaged in independent practice. So you can't have your own name in bold, large font without conspicuously having the name of the firm on that same piece of marketing material. In other words, you can't make it look as though you're running a real estate brokerage business on your own, when in fact you work for a brokerage firm. Now, if you have a broker license and work on your own, then your name could be any size font that you like. The exceptions to the first 2 parts of the name disclosure rule is that you can advertise the occasional sale of real estate that you own, or you can engage in occasional solicitation of real estate for purchase by you without complying with the advertising provisions of this statute that require disclosure of the name of the firm that you work exactly as it appears in a conspicuous manner. The third part of the advertising statute says that you can't advertise a property unless the firm is either listing the property or the firm or a licensee associated with the firm has obtained the consent to advertise the property from the firm that's listing the property. In other words, you can't advertise the sale of property without an agency agreement. That would be a listing contract with a seller. If you want to advertise a property that's for sale and listed with another brokerage firm, then you need their permission to advertise their listing. The fourth part of the statute on advertising prohibits you from advertising a property at a price other than the agreed upon price with the owner. The exception is that the price may be stated as a range, or in general terms if it reflects the agreed upon price. Now, what does Article 12 of the National Association of Realtors Code of Ethics have to say about advertising? Well, the NAR says that your advertising must be truthful and you must disclose your status as a real estate professional. All advertising must contain your firm's name in a reasonable and readily apparent manner. You have to indicate in your advertising that you're a real estate professional. On your website, you have to include the state where you're licensed. You can also disclose your state license affiliation on your website by providing a link to a website that displays your credential. So the requirement under Wisconsin Statute 452.136 is mandatory if you're a real estate licensee. If you're not a member of the NAR, then you're not under their Code of Ethics requirement. Now let's talk about disciplinary actions against a licensee for misrepresenting their affiliation with a firm. It's complicated, so I'm going to summarize the action. A licensed salesperson contacted a seller of a home stating that she worked for a certain real estate brokerage firm as a buyer agent and wanted to show the home to her buyer. No problem. The agent showed the home, then drafted an offer, but the offer didn't state who drafted it, nor did it indicate who this agent worked for. The seller contacted the agent asking, "Who do you work for?" because the offer had no information as to the firm or the agent. The agent said she was transitioning between brokers, but indicated in the offer that her commission would be paid to a certain LLC. The seller checked the DSPS website and learned that the agent, in fact, didn't work for any firm. However, the DFI website indicated that the agent was the registered agent of an LLC, but this LLC was not registered as a real estate business entity. Bottom line here is that this sales agent was not associated with the firm and was disciplined for having to surrender her salesperson's license. This case shows the importance of accurately disclosing your status as a real estate licensee. The law is designed to protect the public. This agent deceived the seller, and the seller did their research and learned that this salesperson was not a broker and had no affiliation with a broker to operate that way that she did. Here's another disciplinary action involving not disclosing the firm that you work for. A salesperson was issued a commission check directly from the title company. The salesperson did not submit any of the transaction documents to his supervising broker for review. As a matter of fact, the salesperson didn't give any transactional documents to the firm. When the salesperson had to respond to a department inquiry, those documents indicated that he was representing himself as an agent of the firm. Of course, this salesperson was busted, among other infractions, for failing to submit to his firm in a timely manner all agency agreements, offers, and other documents that are signed by the parties to the transaction. He acted on his own and failed to deliver the commission check to his broker before he received his percentage. So this agent deceived his broker by acting outside of his authority as a salesperson. The last disciplinary example is with an agent who indicated on a transaction document that he worked for a certain firm. One was never registered with the department, and the other firm was unlicensed when he indicated the firm on a listing contract that he took. Then on another separate offer with different parties, he indicated that he worked with a different firm. One of the firms that he indicated on an offer to purchase was that he owned a brokerage firm that had never been registered with the department. He was busted for engaging in real estate practice while not associated with a firm, failing to state the firm's address or phone number on transactional forms where required, and failing to protect the public against fraud, misrepresentation, and unethical practices. Let's talk about using internet sites and prohibitions. The first rule regards posting articles and starting discussions with a client or other agents on social media. The internet's a great tool to position yourself as a resource for current or future clients. But your use of a website must be consistent with a code of ethics, local, state, and federal laws, and all real estate license laws and regulations, whichever applies. Every internet platform has privacy policies that you can link directly from the platform. I'm sure that most people don't bother reading their policies, and platform policies change from time to time. You probably already know that information that you post on social media sites may be taken by other users and forwarded or shared for purposes other than what was originally intended by you. Client information that's not meant to be public should never be posted. If you're commenting on a site, the host is not responsible for information posted by a third party, say on their blog. But the NAR takes a different approach, stating the obligation to refrain from making false or misleading statements about competitors, competitors' businesses, and competitors' business practices includes the duty to publish a clarification or to remove statements made by others on electronic media that the realtor controls once the realtor knows that the statement is false or misleading. That's the same as Facebook flagging a comment that you make that they deem false or misleading. You have a higher level of duty than a member of the public because you're regulated and you're licensed. The message here is that if you operate a blog, you have certain obligations to delete false or misleading comments or publish clarifications as soon as you have determined they're false or misleading. What about if your listing is posted on, for example, Craigslist by another agent without your permission? Wisconsin Administrative Code Section REEB 23.04 sub 3 tells us that you can't advertise property without the authority of the seller or the listing agent. Any dealing with a property listed by an agent must be conducted through the listing agent unless the agent or broker has given you permission to contact the seller directly or the seller has initiated the conversation. Well, that's it for part 1 of Course 7. I'll see you in the next video.